So it's Monday, July 28th, and by my calculations, today is the day that Ghislaine Maxwell, convicted child sex trafficker, this is the day that she needs to file her reply brief in support of her petition to the United States Supreme Court to take up her appeal. Yesterday, I wrote a very lengthy and very detailed Substack post, really diving into the legal issues that are being raised by Ghislaine Maxwell in her appeal. And the reason why I thought it was important to actually do a video here for the Phang News channel is I wanted to be able to explain it in my own words, one. Two, I wanted to urge you to go and read that Substack post because I think it'll really help you understand why there is a definitive exit ramp that has been provided to the Trump DOJ by virtue of this appeal that's being done by Ghislaine Maxwell that would kind of scratch everybody's backs in a totally dirty way on that side of the fence. So needless to say, Ghislaine Maxwell, having been convicted and sentenced in 2022 to 20 years in federal prison, followed by 5 years of supervised release. I mean, she's in a federal prison in Florida, in Tallahassee, Florida, just about maybe 9 hours north of here. And she wants to get the hell out of federal prison. And look, I don't begrudge that, right? But as somebody who believes in the rule of law, though, after having gone to trial in front of a jury of her peers and having been found guilty by a jury of her peers of multiple federal offenses, the jail time is not only appropriate, but it is necessary. Just as a footnote, it's something called the Criminal Punishment Code. The Criminal Punishment Code is used for purposes of sentencing. And there is of course, deterrent component, which comes from the punitive aspect of it, which is called the punishment. And before I get there, just for a second, look, we want people to be rehabilitated, right? If you commit a crime, we want you to do your time and then go on to be productive members of society. That is the goal. But in the event that you are committing a crime and you are found guilty of that crime and you are being punished, then there is the punishment part of it. And for Ghislaine Maxwell, 20 years followed by 5 years of supervised release, in my opinion, was light. But that is what a judge found to be appropriate back in 2022 in the Southern District of New York, again, after she went to a trial. I'm also going to add the additional footnote. Ghislaine Maxwell had the constitutional right not to testify at her jury trial, and she elected not to do so. Right? Meaning she had the chance to explain that she was the victim of Jeffrey Epstein, as she now claims, that she did not participate in any of the child sex trafficking, child sex abuse, child pedophilia. She didn't do any of that, according to her, but she never took the stand. And as somebody who believes in the Constitution, I don't have a problem if you don't take the stand and you don't speak because you have a constitutional right not to do so. But in this instance, I do take umbrage with the idea that suddenly now you have all this information that you can impart, and you haven't done so. And I get into that in great detail in my Substack post, but let's just start with the legal basics because I know how much you appreciate here at the Phang News channel when we go through the law, because this makes us all smarter and stronger and more empowered when we know what's going on. So Ghislaine Maxwell, again, was convicted in 2022, and she was convicted of a number of crimes, and they were all horrible. And what happened was after she was convicted, she was sentenced. And before she even made it to the jury trial setting, she moved to dismiss the superseding indictment that was filed against her. And she made the claim that because there was a non-prosecution agreement that was entered into by and between Jeffrey Epstein and the United States Attorney's Office in the Southern District of Florida, that meant that she could not have been prosecuted anywhere, including the Southern District of New York. So let's get into those details because I think it's important for you to know. Here we go. So Jeffrey Epstein, as we know, was indicted in Florida. But that's before he was indicted in New York. And a lot of people talk about that sweetheart deal that Jeffrey Epstein got. And so it's worth discussing with you right now. In 2006, a Florida state grand jury indicted Jeffrey Epstein for soliciting prostitution. And at the same time, there was also an investigation being done by the feds and federal law enforcement authorities, including the FBI, into Jeffrey Epstein based upon the allegations that were raised against him. But instead of the U.S. Attorney's Office moving forward against him, he, as an Epstein, ended up getting this sweetheart deal where he only had to plead guilty to 2 state charges, and he was sentenced to about 18 months in jail, but his jail was very loosely done, right? It was this, he could work during the week and only had to do it on the weekends. I mean, it was really just bullshit in terms of punishment for Epstein, which is why it was a sweetheart deal. So back in 2007, this is how Epstein didn't get indicted in Florida by the feds. Do you remember a guy named Alex Acosta? He was Trump's labor secretary in Trump term 1.0. Well, back then, he was the U.S. attorney in the Southern District of Florida. And back in 2007, under his authority, he authorized and he offered to Jeffrey Epstein an NPA, a non-prosecution agreement. And moving forward, we're going to call it the NPA. And the NPA in this instance was entered into by Jeffrey Epstein and the U.S. Attorney's Office, Southern District of Florida. It noted that any prosecution for federal offenses in the Southern District of Florida would be deferred, meaning they would not take place in favor of prosecution by the state of Florida. And so you and I also both know that there was backroom conversations between the state of Florida at the time and the U.S. Attorney's Office to come to this agreement. So the state of Florida also didn't have clean hands in this, let's be clear. The NPA included the following provision. If Epstein successfully fulfills all of the terms and conditions of the NPA, then the U.S. will not institute any criminal charges against any potential co-conspirators of Epstein, including but not limited to 4 of Epstein's young assistants, none of whom was Ghislaine Maxwell. So I'm going to repeat this. The co-conspirators clause that is being invoked by Ghislaine Maxwell that we're going to be talking about moving forward in this video, that co-conspirators clause did not contemplate Ghislaine Maxwell because she was not a part of this deal. Okay? So the co-conspirators clause is the provision that Maxwell is relying upon for the basis of her appeal. But I get ahead of myself. So back on the trial court level in the Southern District of New York, Ghislaine Maxwell moved to dismiss and the judge says, no, I am denying your motion to dismiss. I am finding that co-conspirators provision only applied to the U.S. Attorney's Office in the Southern District of Florida, and it did not apply to the Southern District of New York. After trial, Ghislaine Maxwell appeals her sentence and convictions. The Second Circuit Court of Appeals, considering this argument again that she should not have been prosecuted in the first place because of this non-prosecution agreement, says, nope, we don't buy that argument. We don't agree. In fact, we're saying the following. We're saying that nothing in the terms of the NPA precluded the Southern District of New York from prosecuting you, Ghislaine Maxwell, for your charged offenses. So what is Ghislaine Maxwell left to do? She has filed, a petition for writ of certiorari to the United States Supreme Court. We've talked about that here at this channel. It's the idea that the United States Supreme Court has no obligation to take an appeal just because you file one. So you have to do something called, you have to file a petition for a writ of cert, meaning you have to ask the Supreme Court to take the case. And right now, the United States Supreme Court has not decided if it's taken the case. And in fact, they're still in the briefing schedule, meaning Ghislaine Maxwell filed her petition for writ of certiorari. The United States government filed its opposition brief back on July 14th. And by my calculations, today, July 28th, which is 14 days later, today is the day that Ghislaine Maxwell has to file her reply brief, meaning she has to respond to the opposition brief that the Department of Justice did. But timing is everything, right? And because the Supreme Court is currently on summer recess, it's not going to get to whether or not it's going to grant, the cert that she's seeking for a while. So what is a woman supposed to do, like Ghislaine Maxwell, while she's sitting in federal prison? Well, what does she do? According to media reports, she reaches out to the Department of Justice. She's not deaf, dumb, or blind. She obviously knows the total furor that's going on right now over the Epstein files. Her name is being invoked all over the world. And so because of that, she initiates contact with the DOJ. Stop. I want you to think about that for a second. The Department of Justice, led by Pamela Jo Bondi, lackey to Donald Trump, and then her deputy AG, Todd Blanche, personal counsel and lackey to convicted felon Donald Trump, neither one of them reached out to Ghislaine Maxwell for any information from her. Let's have another conversation. Let's pull on that thread a little bit. Do you mean to tell me that ever since Ghislaine Maxwell got indicted in 2020, and then frankly, Jeffrey Epstein got indicted and arrested and charged back in 2006, do you mean to tell me that Ghislaine Maxwell has never Never had that come to Jesus moment where she's like, I need to sit down with the feds and law enforcement and cut a deal for myself, or I get some type of immunity to be able to flip on Jeffrey Epstein and all the other disgusting people that were a part of this child sex trafficking ring. I mean, what has this woman been doing this entire time? Other than, I don't know, she was hiding out until she got indicted, then she was held in custody, and then she went to trial, and now she's been in federal prison. But even in federal prison, all of that time, being able to think about what's happening in the world, you mean to tell me it never occurred to her that she actually could sit down and try to mitigate her sentence by giving information that would be relevant and could potentially incriminate other people? Again, timing is everything, right? So Ghislaine Maxwell, after reaching out to the DOJ, we know that the Deputy Attorney General of the United States, Todd Blanche, has now sat down with her for more than 9 hours over the span of 2 days last week, Thursday and Friday of last week. And it is unprecedented that a Deputy Attorney General of the United States would go and sit with a convicted felon like Ghislaine Maxwell, and not because it doesn't happen, because it doesn't happen. Because it wasn't one of the prosecutors that prosecuted Ghislaine Maxwell, one of whom was Maureen Comey, James Comey's daughter, who was summarily fired for no reason about a week and some change ago. There are no coincidences in the world, right? So none of those line prosecutors, the people that were on the trial team, that still work at the Southern District of New York, that would know the details and the facts of this case so intimately well so that they would be able to have a bullshit meter that would be so strong to be able to detect if Ghislaine Maxwell was telling the truth during these sit-down meetings. They weren't even asked to come along. Just Todd Blanche. And then let's be clear, we don't know who else was in that room. I presume Ghislaine Maxwell's criminal defense attorney, David Marcus, was present. But other than that, I don't know who else was there. I also don't know, was there a court reporter present? Was there a audio recording being done? Was there a video recording being done? What I do know is this. According to media reports, Ghislaine Maxwell was offered limited immunity. Now, limited immunity is an interesting legal concept. We've heard the phrase immunity before. We've heard it on TV, movies, etc. So limited immunity, though, is very interesting in this instance because the limited immunity is usually offered before somebody goes to trial, right? Before somebody goes to trial, because when they're sentenced, the fact that they went to trial is actually factored into their sentencing guidelines. So in this instance, limited immunity was given to Ghislaine Maxwell so she could sit down and have a conversation with Todd Blanche. But that queen for a day, which is this idea that, and I used to do this as a prosecutor, I would give certain defendants, if I thought that they had some value in terms of information, I would give them a queen for a day letter, meaning you could be the queen for the day, that you could speak to me and other law enforcement. You'd have to tell the truth, right? And if I found out you told the truth, then the deal was off and your immunity was gone. But if you tell me the truth, then I promise not to use what you tell me against you in court. Now, listen, if through independent investigation means I find out something about your involvement in criminal conduct, I can still go after you. But when we sit down together and we have this ostensibly heart-to-heart, honest conversation, you're telling me the truth. In exchange for that, I will not use it against you in court. But we have to pump the brakes here. Because for somebody like Ghislaine Maxwell, who's already gone to court, who has professed her innocence and claims that she didn't have anything to do with it, and that furthermore, she shouldn't have been prosecuted pursuant to that co-conspirators clause in Jeffrey Epstein's non-prosecution agreement, then what could she possibly have for value? Because let's not be naive and stupid here. Because Donald Trump holds literally the keys to her freedom. He is literally holding the keys to her freedom by way of a pardon or by way of a commutation. So, of course, Ghislaine Maxwell suddenly has information that she has to share. And you and I both know that that information that she has to share exculpates, exonerates, completely gets Donald Trump out of the trouble, right? Just says he was an innocent bystander. He maybe rode on a plane or he maybe, broke bread with Jeffrey Epstein once in a while, but there's no way that Donald Trump did anything untoward with a little girl. And then Ghislaine Maxwell probably says, but let me tell you about Bill Clinton. And let me tell you about all these other Democrats, because those Democrats are bad people. I've seen people saying that she was convicted of perjury. She wasn't. She was charged with perjury, 2 counts, but those counts didn't go to trial, which is fine. It was prosecutor discretion not to go to trial. Well, first of all, they couldn't go to trial at the same time with the other offenses because it would be too prejudicial. But in the end, they didn't go to trial on the other ones because they got their win and they didn't need to. But here, I have talked about the sentencing memorandum that was written by the Department of Justice when Ghislaine Maxwell was being sentenced for her crimes. And that DOJ sentencing memo is scathing in terms of calling out Ghislaine Maxwell for being a serial and compulsive liar. She lies. She lies to save herself. She lies to protect Jeffrey Epstein. She lies to protect the other uncharged co-conspirators and unnamed others, people that were clients on a client list. She protected them by lying. She lied to mitigate her involvement, and she lied to basically cover up for every other people. Okay. So I want to talk about this non-prosecution agreement, theory that she has, because in my opinion, I feel like it's a way by which Ghislaine Maxwell could get out of her situation. She could give Donald Trump everything he's looking for in this instance, and she could basically get her ticket to freedom. So very quickly, we went through the non-prosecution agreement a couple of minutes ago. And here's what's interesting though. The Trump DOJ filed a response in opposition on July 14th, meaning that they said no to Ghislaine Maxwell's, option or attempt, to try to get the Supreme Court involved in her appeal. And the thing that the DOJ raises is this, that back at the time of this non-prosecution agreement, DOJ policy then and now says that no district or division shall make any agreement, including any agreement not to prosecute, which purports to bind any other districts or division without the express written approval of the U.S. attorneys in each affected district and or the assistant attorney general of the criminal division. That never happened. The Epstein non-prosecution agreement was signed by Epstein and signed by the U.S. attorney, Alex Acosta. Remember that name, as well as the assistant U.S. attorney for the Southern District of Florida. There was no one in the Southern District of New York who was implicated in this. In addition, the DOJ makes the following argument as well. Policy, long time, then and now, policy for the U.S. Attorney's Office is this. There is a longstanding general rule that a U.S. attorney's area of responsibility is limited to his district. So again, there's no indication that anyone involved in negotiating Epstein's NPA obtained the necessary approval for binding other U.S. attorneys' offices or thought that it was necessary. So what does Maxwell do? Maxwell then says that, prosecutors should be made to honor their promises that they make. They should keep the promises that they make. And yeah, I think everybody should keep the promises that they make. Donald Trump should keep the promise that he made on the campaign trail when he said that he was going to release all of the Epstein files because he was screaming about transparency. That's a promise that should be kept. That's a promise that other Republicans are asking to have happen. But anyway, so Maxwell's right. Prosecutors should be held to that standard. But in this instance, it wasn't a promise to be made by the Southern District of New York to Ghislaine Maxwell. It certainly was not made to Jeffrey Epstein, right? And how do we know that? Because Jeffrey Epstein was indicted by the Southern District of New York in 2019, approximately 13 years after he was prosecuted by the state of Florida. So look, by all accounts, this attempt by Maxwell to get the Supreme Court involved should fail. And by all accounts, on every legal basis, it should fail. But here's where Donald Trump could really use this to his advantage. So Todd Blanche comes out of this meeting with Ghislaine Maxwell, and he makes all of these representations. Whether they're true or not, I guess we need to find out. We need to litmus test it. But if Todd Blanche comes out of those meetings with Ghislaine Maxwell and he says all of these things that she implicates all these Democrats, etc., then Todd Blanche could then say, and you know what? Ghislaine Maxwell is a true co-conspirator to Jeffrey Epstein. It doesn't undercut the truth, according to Blanche and Trump, of what she says. And it pretty much satiates the base by saying, look, this woman was just as involved as Jeffrey Epstein. However, because she was a true co-conspirator, you know what? We've looked at this and we actually think that the non-prosecution agreement's co-conspirator provision, it actually should apply. And you know what? We're going to actually not agree anymore with what we filed in our brief in opposition. And we're going to, support this idea that she shouldn't have been prosecuted. And so we're going to basically agree that she should not have to be in prison anymore and that she never should have been prosecuted in the first place. They're going to wind back the hands of time to 2020 when Ghislaine Maxwell was indicted. I know to my Substack post, it sounds freaking crazy, but you know what? This administration does whatever the hell it wants to do. To hell with the law and procedure and with decency. And so Ghislaine Maxwell could be rewarded for what she says by getting out of prison, by way of the pardon or the commutation, or even by this crazy NPA thing, which is, look, you know, she's still guilty, but she never could have been prosecuted in the first place. And we're going to blame Alex Acosta because Alex Acosta was terrible by allowing this non-prosecution agreement in the first place with Epstein. And it was so badly drafted that it actually includes Ghislaine Maxwell. And listen, we've seen that there are people that are willing to put their mouths as mouthpieces for this insanity for the Department of Justice, right? We heard that from whistleblowers from the DOJ that people are willing to do this. Emile Bovee, Todd Blanche. So I wanted to put this out there for you guys to think about, because I haven't heard anybody talking about this non-prosecution agreement. I haven't heard anybody talking about, you know, Ghislaine Maxwell in terms of her pursuit of getting out of jail. I'm hoping, though, that conventional wisdom is Blanche is just going through the dog and pony show in a very performative bullshit way of going and meeting with Ghislaine Maxwell so he can say, I met with her and there's nothing there. Just like, you know, Pamela Jo and I said that there's nothing there, you know, this is just a big nothing burger in terms of, you know, there being something there. I mean, but what a risk, though, because this MAGA base isn't going to be satisfied with that. They've clearly shown that they want more. And the timing is also really important because, as Congressman Robert Garcia told me here when I interviewed him here last week, they're aiming to interview Ghislaine Maxwell in prison on August 11th. Tick-tock, honey. That's like in what, 3 weeks and some change? If that's the case, Ghislaine Maxwell is going to have another opportunity to speak, assuming arguendo, it actually happens, right? That deposition happens before Congress, or before the congressmen and women, by the way. She's not going to D.C. According to Congressman Garcia, they're going to go to Florida, but whatever. But the thing is that everything is very kind of essential and critical in terms of timing. Blanche has promised at some point he's going to tell us what she said, but we all know that promises are not kept, that they're broken with this administration, so I'm not holding my breath. But I'm going to see what the reply brief says for Maxwell. I'm going to see whether or not she references in any way, you know, her conversations with Todd Blanche. I doubt it, but you never know. Because again, it should be filed today before the Supreme Court of the United States. But stay tuned, watch the space, because I'll have more information for you, and I think it's worthwhile sharing. I'll see you on the other side. Katie Phang here. We launched the Katie Phang News Channel in partnership with the Midas Touch Network so we could bring you the latest in legal and political news. Straight, no chaser. So if you're a fellow truth teller, hit that subscribe button and share the word about this channel so we can build a high information America together.